it's impossible to maintain that the original tribunal explicitly decided that the data used for historical losses was inadequate to provide all the data necessary for calculation of the loss of value damages and can have the status of res judicata for the present tribunal and bind it in relation to the calculation of those same loss of value damages, and this is the end of paragraph 83, while at the same time maintaining that having been awarded damages in respect of the 2008-2010 period, in a portion that stands as res judicata, this tribunal considers that claimant is entitled to recover those same cash flows through 2013. Especially if the tribunal is to find, as it did in paragraph 138, that the same data and methodology as was accepted by the original tribunal is to be employed to calculate the amount of these further entitlements. It's not like the second tribunal made its own independent query into the evidence and by happenstance reached results that are compatible with those of the first tribunal. The second tribunal, having said it should use different data, different methods for different reasons because of different legal causes and considerations, then went on to say the same data and methodology as was accepted by the original tribunal is to be employed. Paragraph 138 assumes that the second tribunal is under a mandate to apply the same method and the same data and methodology, which it had started from the premise it should not use, and it should supplement by the evidence in the record of the resubmission tribunal. This is perhaps the quintessential contradiction that calls for the resubmission award to be annulled. These are genuine contradictions that cancel each other out and called for annulment of the resubmission award under Article 52(1)(e), as discussed in Mine v. Guinea. Of course, as the committee knows, let's say part of the canon of analysis of the failure to state grounds as a ground for annulment under Article 52 of the ICSID Convention, a decision on annulment that was authored by, among others, the often called architect of the ICSID Convention, Aaron Brooks, as chair of the annulment committee. Again, the committee in Tidewater v. Venezuela, but also because of the same positions that TECO had argued before the first annulment committee, and which the first annulment committee had in fact accepted. Let us now go for the last few minutes of my presentation to the issue of post-sale interest.
Sorry, Councillor, before you turn to that matter, when you were dealing with the actual value of the shares, and you said that in reaching that decision, the resubmission tribunal had incurred in a serious departure of a fundamental rule procedure. You said that that argument had already been made in Guatemala's submissions right from the beginning. And you took us to paragraphs 224, 225, and 226, I believe. Are you referring in these paragraphs to the actual value or to the but-for value?
We are referring to the value, and to the extent there was any doubts as to whether that applied to other areas, that was precisely what was clarified in the reply. So in the event that there's any portion of the argument that could still be responded to, as TECO did indeed in its counter memorial on annulments, then the issue was further enhanced and clarified and provided arguments for in the reply arguments. The only actual requirement for there to be a statement of grounds of annulments in the application for annulment is, of course, that every single ground be identified. And this is, of course, the language in Article 52 of the ICSID Convention. Then the responsiveness of every argument, every single word that appears in paragraph 224 to 226 of Guatemala's memorial can be predicated of both the but-for and the actual value. At the end of the day, the only finding of damages is the difference between one and the other. So the fact that in either of those elements or both of those elements, there is a glossing over evidence, there's a failure to state grounds, there's reasons that contradict each other, there's a failure to address the arguments submitted by the party, that itself leads to a serious departure from a fundamental rule of procedure that affects the conclusions reached by the tribunal. We don't think that there's sufficiently discrete matter being discussed in the actual value or the but for value, but at the end of the day, it's A minus B that leads to the actual finding.
Yes,
by the
I
tribunal.
understand. But what you were focusing on in these 3 paragraphs is on the lack of explanations regarding Guatemala's evidence on the but-for value. Is that correct?
It was the failure by the tribunal to treat that evidence.
Yes.
Yes, you're correct. It was, by which I mean, it was not an area of failure to state grounds, but serious departure.
It's a serious departure because it did not address what
evidence.
criticisms regarding the but-for value. Is that correct?
Yes.
Then I think I'd need some further input on what evidence they existed, and this goes to both parties, during the resubmission proceedings regarding the but-for scenario. So is it because we've got the reports and it seems like they were exactly Kaczmarek. We've got a Polish colleague who told me that that's the correct way to pronounce that name. So Kaczmarek submitted this. The report submitted in the resubmission proceedings was the same as the one that existed regarding the but-for scenario. Was it the same? So the cash flows were exactly the same. Were they calculated at the same value in the but-for scenario? That's one of the questions. What is exactly the same? And then were those for the period between 2010 and 2013? Was it just a continuous projection of the cash flows estimated for 2008 up to 2010? Or wasn't it just a projection, but were there other elements that were considered? Because we've heard a lot about this arithmetical approach, like it was very simple and all evidence could have been disregarded in the resubmission proceedings because you could just take what the original award decided and somehow continue projecting it. But I would like to know how that should have been. So it is just, well, we've got these cash flows and I just continue and at some point I'll have to discount them, or whether some other elements involved to make the projection for 2010 to 2013. Did you get my question?
I did. We'll be happy to provide any deeper dive into the evidence for closing arguments tomorrow, but I have already...
You don't have to address it now, but since I can already anticipate it, so if you can do it in the second round, that'd be great.
But I would still like to offer a preliminary answer because it's something that we have already seen in some of the slides. My first and shortest answer, and we will of course hear any additional thoughts from claimant later on, but the valuation case submitted by TECO was the same, meaning projected from the first to the second periods, as had been argued in the first arbitration, which is why we had citation to transcripts from the resubmission hearing where Ms. Menaker was discussing how and why TECO considered that the facts as accepted in the first arbitration should be granted res judicata status for purposes of the second proceedings, and that if res judicata was not granted, it's still the evidence to which it referred should be assumed to be correct and stand. And in the case of Guatemala did make additional an additional review of the evidence and did make additional considerations. They introduced additional considerations dealing with issues of damages, and in a visible nutshell of that, we see the discussion that we had a slide which I managed to lose somehow to the examination, to the comments by Mr. Alexandrov in the resubmission hearing. So at the resubmission hearing, they were discussing these 4 elements that would change the but-for value, and so the position the resubmission tribunal was adopting at the hearing, there was a closing arguments by President Lowe. If we can go to the other slide with the transcript was cited. President Lowe is saying there, this is, I think, page 817 of the resubmission hearing. That's a range of issues on which we would be particularly interested in hearing more. So this simply speaks to the fact that there was a discussion on these 4 elements that appear, if I'm not mistaken, in the preceding slide, slide 76, that are corrections that have to be introduced to the valuation of the but-for in the but-for scenario. And you will notice that these criticisms appear in the third Compass report of 2018, and we have citation here to the paragraph in that third report. So this is all materials that were introduced before the second tribunal directly. I don't know if that addresses Madam President's issue sufficiently, or
no, I mean, you still have to, no, sorry. I still need to understand how these projections were made and how far they included specific elements projected for that period, or there was just a general projection of what they did for the first period and continued it. I need to know.
We'll be sure to address that in detail for tomorrow's closing arguments. Thank you. Thank you very much. And to the extent there's any question that any member of the committee has to any of these points, we of course welcome them as they come up to your minds. They feed into our ability to speak to your concerns there. So let us, with committee's leeway, let's proceed to the issue of post-sale interest now. And the parties had basically these 2 positions. On the one hand, there should be, said claimants, interest should be awarded as from the date of that sale in October 2010 at US prime rate plus 2%, while respondents said interest should be awarded at a risk-free rate. And we mentioned this in passing already earlier today, but basically the legal theory under which as from the date of that transaction, the only way to calculate interest validly is through a risk-free rate is because the claimant is not exposed to any form of commercial risk anymore. And so the only way to validly update any figure from that moment onwards is through a rate of interest that simply accounts for the time value of money. And that is the risk-free rate, typically calculated by reference to, for instance, U.S. Treasury bonds of there's some discussion between decisions in tribunals. Is it 6-month T-bonds? Is it 10-year T-bonds? But at any rate, that's conceptually what risk-free rate is. And the tribunal, first tribunal, we have next slide 89. Paragraph 766 says, the arbitral tribunal agrees with the respondents that applying excess WACC stands, of course, for weighted average cost of capital, which is the commercial cost of financing that an entity of that type and source would have to pay to a combination of equity holders and financiers, and the weighted portion of that acronym is exactly how the portion that goes to equity should be measured relative to the portion that goes to financing. And of course, the reason for that is that the cost of equity is conceptually always higher than the cost of financing. And so the tribunal says it would make no sense to apply the cost of capital of EXA post-October 2010 because claimant had sold its interest in EXA and ceased to assume the company's operating risks. So we have here a reason and a consequence. The company is not exposed to commercial risks, that's the reason. Then we shall use a risk-free rate, that's the consequence. Now, in the following paragraph, and we are at slide 90 now, Tribunal went on to say, the Tribunal agrees with Mr. Kaczmarek's evidence that the proper interest should be based on the U.S. prime rate of interest plus a 2% premium in order to reflect a rate that is broadly available to the market. There is, unlike in 766, which had a reason and a consequence, there is no reason why a commercial, that is to say, non-risk-free rate should be applied, especially if the first tribunal had started from the premise that a risk-free rate was appropriate. But
Mr. Gossi, sorry, why was there a reference to the WOC? Were there two claims for interest? The primary claim was for the WOC and subsidiarily it was prime plus 2?
I understand that is the case. But
No? Because this is apparently Kaczmarek's proposal to use prime plus 2, but the tribunal had already ruled that WOC was inappropriate. So
If I may, just as a factual matter, the WACC was agreed by both parties for the pre-sale interest, which was that $846,000. And then there was an issue as to what interest is on that interest. And that's where we argued it should be U.S. prime plus 2%, and they argued it should be risk-free rate.
okay, I get it. Thank you. Thank you.
but both you and us, and it's unfortunate that neither of us were there at the time of the first of the first arbitration, but we have to take this portion of this first award at the face value it carries, and because, and this is something that we'll get onto in a second, but because it was not annulled, and as a result, it has become res judicata. And what it does say is that applying the WACC post-October 2010 would make no sense. And this is all that we know it's saying. This is the reason it's granting. There's no risk, so applying an interest rate that would recognize any form of risk simply makes no sense. And this is what this says. Then 767 says, Tribunal agrees with Kaczmarek that the proper interest should be based on the U.S. prime rate plus 2% premium. The first ad hoc committee annulled, and remember this is 766, 767, it annulled paragraph 765, right above 766, and 768, right below 767. And as we can read from the second award, paragraph 130, which we have on the next slide, only paragraph 765 and 768 of the award, of the original award, were subsequently annulled. We go on to read at the end of this, at the beginning of paragraph 131, in the present proceedings, attention was focused on paragraph 766 and 767, which were not annulled. And of course, not having been annulled, they became res judicata. There's nothing the second tribunal or even this second committee could do to strike those two paragraphs from the awards. Because, of course, under Article 55.3 of the ICSID Convention, any portion of an award that was not annulled cannot be reconsidered by subsequent adjudicators in the same dispute. Now, importantly, this paragraph 131 also contains the following reference. There's an apparent inconsistency between paragraph 766, which indicates that a risk-free rate should be applied, and 767, which applies what is evidently not a risk-free rate. So the second tribunal acknowledges that US prime plus 2 is not a risk-free rate. This is not an issue of how we calculate a risk-free rate, because the second tribunal starts from the premise 766, first tribunal said we shall apply a risk-free rate. 767, whatever is in there is not a risk-free rate. That is, without a doubt, inconsistent. So this makes it impossible to agree with TECO when they say, and we are slide 95, if I may, the paragraph 222 of their rejoinder on annulment, that there is no contradiction between the resubmissions tribunal's statement that after TECO's sale of the investment was no longer at risk, and its award to TECO of post-sale interest at US prime plus 2%. Because as we saw in paragraph 131 of the second award, the second tribunal itself admitted that what 767 awarded was not risk-free rate, while what 766 awarded was risk-free rate. So it's simply impossible to maintain that there is no contradiction. And the reasons provided in 766 that applying a WACC post-October 2010 would make no sense speak specifically to this contradiction, because a WACC would be a rate which is not risk-free. It is the commercial rate that would be obtained. It's the cost of financing that would be obtained by EXA, and not a rate that would consider that no commercial risks were affecting the investment anymore. So the same paragraph 766 contains, as I was mentioning before, both the reason why and the effect of there being no risk to which the investment was exposed. Now, the second tribunal could have liked the first award. It could have disliked it. It could not have annulled it, which it did in practice in deciding to apply paragraph 767 to the detriment of 766, as it did in paragraph 135, where it says, the majority of the tribunal agrees with the original tribunal that the US prime rate of interest plus 2% is payable both pre and post award until the date of payment. So when it does that, and the citation here, of course, is to the original award, paragraph 767 in footnote 118 of the second awards, we had it still in slide 94. And this is part of both the contradiction, before we move on to the manifest excess of powers. First tribunal says there is a portion that was not annulled. The portion that was not annulled is unclear, and we are halfway through paragraph 131. A majority of the tribunal considers that these two paragraphs do not have res judicata. And we're still at paragraph 131. The tribunal finds, for these or other reasons, it is not bound to apply the interest rate set in paragraph 767. You see that the last three lines of paragraph 131. The second tribunal says we are not bound to apply paragraph 767. Yet, it decides not to apply paragraph 766, but to do apply paragraph 767, as we see in second award, paragraph 135. The majority of the tribunal agrees with the regional tribunal, citation to paragraph 767, that U.S. prime rate of interest plus 2%, which the same tribunal considered was not a risk-free rate, shall apply. It is simply impossible to do that without depriving paragraph 676 of its effects and in practice annulling paragraph 766. Now, we go to slide 96. It is a manifest excess of powers if a tribunal goes beyond its jurisdiction. Suffragi be EAU.
One point. Could the parties at some point look whether, I think the WACC was set at 8.8. Could they please look at whether prime plus 2 always remained, I assume, below 8.8?
We could look, it fluctuates, of course.
It
with
fluctuates
prime rate.
until 2020, whenever Guatemala paid. So
Oh,
during,
we could let you know that and look at a spreadsheet.
and if there were projections at the end, whenever the second award was issued, as to how US prime would evolve in the future, but I assume it will always be below 8.8. But if you could check it.
My, I'd say, recollection from heart is that it always was, that it was always above the risk-free rates and below 8.8. But of course, we'll go back to the committee with specific analysis on that for tomorrow.
Risk-free rate understood as the treasury bonds, right?
Yes.
US.
US treasury bonds, yes.
Could I just ask, since we've had this interruption, if we could have a time check? I believe.
Yes. I'm starting to feel hungry, so it tells me that we should be approaching the lunch break soon. I don't know who's.
Yes, but after that, I mean, I still have 25 minutes, and I think it would be prejudicial for Guatemala if we stop here and we have just last 25 minutes.
Well, I'm not asking for a break to cut up your presentation, but I actually thought we've been going for 2.5 hours with your presentation, but I'm not a timekeeper.
2 hours, taking into account the grids.
Yeah, 2 hours.
You will still have half an hour left.
And that's what I was asking. We have about a half hour more. Is that?
I'm looking at the real boss here. So, Trevor, do you need a break? Are you fine?
We'll continue for half.
He's
Thank
the
you very
boss,
much.
so he's okay in continuing for 30 minutes.
Thank you, Trevor.
Would 30 minutes be? I mean, that's
Yes,
what you have allotted.
it will.
So
It will. Thank you.
Perhaps you need to skip some of the slides.
And I will.
Okay,
And I will.
excellent.
Just before we move on, may I ask a question about 131? What is the contention, if any, of Guatemala with respect to the views expressed by the tribunal in 131 about the res judicata question? Are you challenging that, and if so, on what basis?
We have, and thank you for your question there. We have two threads of issues with 131. One of them speaks more directly to 131, and the other probably goes all the way down to 135. But on 131, it is inherently inconsistent to recognize that there's two paragraphs which have not been annulled, but that they still will not be applied.
I understand that argument, but I'm trying to see whether you are effectively, by that argument, seeking to challenge the tribunal's conclusion about res judicata in 131.
I think if the tribunal meant something by saying that it's not annulled, but denying it of res judicata, that made sense, it should have said expressly what it was that it was saying and why it was reaching that conclusion. That is nowhere to be found in the award. And that's one of the ways in which, as per TECO's theory,